Our clients were a group of brothers, and they were the beneficiaries of a couple of different trusts. Those trusts had held at various times millions of dollars worth of real estate assets, cash, investments in various projects. To be told there's no money left is a shock. Our clients came to us in 2020. Without ever providing any documentation, the trustee came to them and told them, we're out of money. And actually, he said, we no longer have the money necessary to pay for your mother's long-term care. She was in a long-term care facility. So obviously that's surprising news when, to your knowledge, this trustee has been responsible for in excess of $12 million. So they asked for an accounting. And the only response they got was, I lost as much money as you guys did. And so they hired us, and the first thing we had to do was file a lawsuit for an accounting of the assets, which led to the turnover of hundreds of pages of bank statements, thousands of documents showing transactions for a 20+ year period. And using that evidence, we were able to quickly determine both a long pattern of misuse of trust assets and a recent real estate deal. He had told everyone and papered a deal that said, I'm paying hundreds of thousands of dollars to this third party for this investment, but that transaction wasn't real. And we were able to trace the money and show that he took cash directly out of a company account that was owned by the trust and used that money to pay off his personal credit cards. Now, in that suit, we pursued a couple of different avenues. One of those avenues was providing a packet of materials to the district attorney in Douglas County so that he could pursue a felony claim for theft against this former trustee. In the course of that proceeding, he wound up pleading guilty to felony theft for the crime of stealing from our clients. We also were able to chase him into bankruptcy court because he declared bankruptcy on the eve of trial in order to evade a possible judgment. What we learned was that the former trustee had listed for sale his home and the attached property in Douglas County. We went to the court and we were able to prove that there was a likelihood that this gentleman was divesting these assets in order to defraud his current creditors and to render himself uncollectible. Part of that was sort of making the case that there was a likelihood he would flee to Mexico. We actually established that he had a condominium in Mexico. So what we had to do was file an appropriate motion for prejudgment writ of attachment with the court, establish a likelihood that he was using this sale in order to render himself uncollectible. And on those facts, the court granted our request, and we recorded in Douglas County a writ of attachment showing that that property could not be transferred, and if it was, it would be subject to our rights. Now, in that case, the transfer actually went through. The title company approved the sale of these homes, notwithstanding our writ of attachment. What that meant was that after we obtained our judgment in bankruptcy court, we managed to negotiate with the title company and say, we're going to foreclose on these homes that are owned by these new individuals because you sold these properties and allowed the sale to go through with knowledge of our writ of attachment. And so we were able to secure a significant recovery for our clients from a third party in order to obtain relief that we frankly could not have obtained from the judgment creditor. We obtained a $3.6 million judgment in 2023. During that time, we litigated extensively in state court. We litigated in federal bankruptcy court. We achieved a significant judgment that fully vindicated. And listening to the bankruptcy judge in that case she said, this judgment creditor is the least credible defendant I've ever seen in my years on the bench. That validation for the client, that what they'd experienced, what they'd lived through was real, was really valuable. And then the icing on the cake is securing a significant monetary recovery for the client as well. That case represents the gold standard, the standard we hold ourselves to of achieving a complete result. We achieved the outcome in the courtroom that we wanted, and we achieved the monetary outcome that the client deserved.